Welcome to the Trusted Podcast with your host, Blake Johnson. In each episode, Blake interviews professionals in different areas of life that you need a trusted source of information, including trust and estate planning. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcast, Spotify, and on our website, trustedepa.com. Now, here's the host of Trusted Podcast, Blake Johnson.
Hello and welcome to the Trusted Podcast. It's great to be with you again today. I'm flying solo again because I've got another really important topic that I want to discuss today. I want to talk about why the need for planning when you think that your family will all get along and that there will be no issues. I'm here to tell you, surprise, your family is not exempt from fighting. You're not going to be the exception, has been my experience. I hope I'm wrong. I hope that your family gets along great when you pass away, that there's no fighting, no issues, everybody's on the same page. And we're going to talk about some steps you can take to help mitigate that. But my experience has been that that's not the case. You know, I've hear it all the time. Oh, my kids are great. They're going to get along. Everybody's going to do the right thing. I trust them. No one's going to make them, do anything that would be selfish or anything like that. They'll never fight. They'll do the right thing. I hear it over and over and over again. And sadly, it's just not the case. When mom and dad pass away and they don't have that central factor to bring everybody together, make everybody on the same page, and there's money involved, people change, and there's going to be fights. So I've got a couple of stories for you to kind of illustrate that. One of the big ones that I see and hear about why someone doesn't need to do a trust is, well, I've already put my kid on my house. And so that was my only asset. I don't need a trust because they're on there as my joint tenant, and the house will just go to them and they'll make sure it goes, when it's sold, everything goes equally amongst the siblings. In theory, that's great because, yes, if there's a joint tenant, when somebody passes away, whoever the survivor is, they now get the property by themselves. But there's a couple of issues with that. So the first one is, while you're living, that joint tenant, if they get sued, your house is now subject to that lawsuit. So you could lose your house just because your kid gets in a car wreck or does something wrong, gets mad, hits somebody, whatever the case may be. Now your house can be lost because it's subject to that lawsuit because it's their asset now. You've actually transferred ownership to them, and that creates issues. The second thing from an estate planning perspective is they don't have to share. And when that reality sets in, there's no legal recourse. So if you have 3 kids and it's always the oldest, they put the oldest kid on property, and mom and dad pass away and it goes to the oldest kid with the idea that they were supposed to share a third amongst them and then their 2 siblings, they don't have to. And there's nothing those other kids can do to change that at all. So it can be a big problem there. If they don't want to, they don't have to. The other issue is, if that house is worth a lot and now they're giving the other 2 kids, even if they're following mom and dad's wishes, they might have gift tax issues because they're gifting more than $18,000 or $19,000 of value in 2025. And that requires filing a gift tax return. And so there's complications that are involved there. So a lot of issues with leaving your kid as a joint tenant on your real estate. So not recommended. Same thing goes if you're leaving it on a bank account. It's all the same issues. Exposure to liability. They don't have to share. That's the one I see a lot, probably more than property, because I want my kid to be able to pay the bills or to pay for my funeral and whatnot. Well, whatever's left over is theirs at that point. And they don't even have to disclose that to their siblings. So there's no way of even knowing that they got that money. So just be really careful and think through those things to make sure it's actually what you wanted when you're doing your estate planning. Let's talk about putting on a trustee that is it's a child, and you're putting them on as trustee now because you want help paying bills and doing that kind of stuff. So this is someone who's done the right planning, trying to do the right thing. Unfortunately, they chose the wrong kid to put on there, and that can lead to some problems, because when they're the trustee, they are the one who has the signing ability. So I had a client in Nevada, and he was getting quite up there in age. I think he was over 90, and wanted help with the day-to-day stuff, especially because he had property in different states and managing that. So he put his son on as the trustee, and the son then went out and transferred the properties that were out of state into his own personal name and essentially stole from his dad. And so we had to remove him as a trustee. He got really nasty, tried to file some lawsuits, ended up putting his daughter on as the trustee for when dad passed away, and he sued his own daughter, which is pretty low to do that. And she tried to do the right thing because she wasn't the only beneficiary, and so she had to sue her dad because of him stealing the property, and that created all sorts of issues as well. So, biggest way to avoid that is really think through who is going to be your trustee. There's a reason they call it a trust. You have to trust that person really well to make sure they're going to do the right thing. If it's just one individual, is that person really trustworthy and going to carry out your wishes? Sometimes it might be better to name two individuals so that two people have to sign and you have some checks and balances there. The other option is that you have a corporate trustee. So whether that's a bank, a trust company, someone who's professional, who are going to have more than one set of eyes on this, and it takes a company decision to move forward on those things and company documents to verify, so that can help protect you as well. Now there's costs associated with that, but those are kind of your options to think through. Just make sure you really trust that person. Just as an FYI, trusts come from the Middle Ages when the lords in England were going off to fight the war in Israel and doing the Crusades. And they would, because if they were gone, they need somebody to run their estate, their land, and their rights. And so they would they would basically transfer title to an individual and say, this is now yours. I'm leaving it, trusting you that you will give it back to me when I come back. And that's how it started. And that's why it's called a trust, because I'm trusting you to return it. And so when they would return for more, then that individual would have to transfer title back to that individual's name. And so a lot more trust involved there than an actual trust that we do now, where it's paperwork wise saying you are the signer on this. It's still owned by a separate entity, but pretty fascinating bit of history. Let's see. Here's a great example of people fighting. Everyone thought they were on the same page, and it ended up not being that. So I had a client, and her husband passed away, and she wanted to make some changes to her trust. We had all three kids on the phone with her talking about the changes that she was going to make. Everybody was in agreement saying, yes, we think that's a great decision. We think that'll work out well. Let's go ahead and make those changes. I started drafting those changes, sent it to mom to sign. Unfortunately, she passed away before she could get those documents executed. Had a follow-up phone call with the kids, and they were still like, hey, is there a way we can carry out those changes that mom wanted? Because that's what it's her wishes. That's what we want to do. I said, yeah, there is a way. We can do a non-judicial settlement agreement. If everybody's going to sign off, then we can make this happen. They said, okay, let's do that. So this is even after mom passed. They said they were all in agreement. They meet and come in to sign the document, 2 months later, because that's when everybody was all together. And when they come to the office, son sits down and says, I'm not signing that. I don't agree with it at all. And, I want the original agreement that was done with both my parents. This one doesn't apply. And guess what? He was right, because he wasn't willing to sign that. We had to go back to the old agreement, which arguably favored him a little bit more, just in regards to being trustee and that kind of stuff. So you got to be careful. Get your documents signed quickly, because even if you think everybody's on the same page, they all said it, and when it came to executing, they couldn't get along and couldn't get it done. So just want to give you some of those examples of how that happens. Other issues I see with that, it's kind of similar scenario, is I had a client who talked about making changes for 8 months And when they finally agreed, I'd already drafted all the stuff actually, and it took him 8 months to get back to me with one little change. And I sent it right back, within a day. He sat on it for another 2 months and then died, passed out in his yard. And so those changes never took effect. And because of the family dynamic and the different beneficiaries, there's nothing we can do about it, because there's no way all those people are agreeing, because it definitely changed it for some of those beneficiaries. So don't sit on it for too long. Taking action and getting something done is always better than waiting and doing something and thinking you have to get it perfect. A quote that I love is, done is better than perfect. I think that applies to any part of our life, but take the action, get something in place that's pretty similar, or at least gives the shell of what you want. And then you can always refine it more and more as time goes on. And that's going to be a better way to do it. But don't sit and wait and think you have to get everything perfect the exact time that you're doing it. There are ways to amend documents, to make changes and make those updates. So don't sit on it too long. Last story I want to share is probably the most common scenario I see. You have mom and dad. One of the spouses dies. Let's say mom dies, and dad gets remarried. And the original mom and dad had three kids. And the idea was that everything would go to the survivor of mom and dad. And when they passed away, everything would go to their 3 kids. Well, by dad getting married, he doesn't ever do any estate planning documents. He just thinks, oh, well, I still would like my wife to get taken care of. She can live in the house and do all that. So, and he just never gets around to making the changes. Well, what happens is, depending on the state and the probate laws, is the estate goes to the wife, and it either all goes to the wife, or half of it goes to the wife, half of it goes to the kids. Either way, it's not an ideal scenario, because you now have these 3 kids who own a house with their stepmom, or stepmom owns it now. In the first scenario, if it's half and half, there's fights there. Kids want their money. They want to kick her out, but she owns 50%. They all have to agree on whatever they want to do with the house and the other assets of the estate. And that gets real messy real quick. As you can probably tell, lots of fights break out. And it's a big problem in probate and in the estate world. So that's a reason to get it done itself. The other scenario is, let's say they leave everything to new spouse. Well, now, because it's hers, she doesn't have to leave anything to the original 3 kids. And so they are now disinherited, because she's going to leave them to her kids. Why would she leave it to the other ones? That's just the way it's going to go. And so, or if she does no planning and it's all in her name, well, guess what? Now it is for sure going to her kids. And mom and dad's original 3 kids get nothing of this estate that was their parents initially. It's all going to step siblings that did nothing, were not part of the family. That's not even their parents who did anything to build that. And that's a really sad scenario. Unfortunately, I've seen that play out over and over again. So those are my stories today, to kind of get you to take action. Don't wait too long. Get something in place and get moving. So with that, what are some things you can do to help prevent the fights? Biggest one is talk about things with your spouse and with your kids. Tell them what the plan is. Make it so it's not a secret. Everybody knows. It's all up front. Hey, this is what I'm doing. This is what I want. And here's what we're going to do. And then execute that document. That's the key. You have to execute it, because if you don't, then there's issues and people can withhold. But if you execute a document and discuss with everyone, that helps prevent fights more than anything else. People just don't know, and that's when problems come up. But if you're clear on your communication, that's going to be your best way to stop any of those fights from happening. Use a trust. As I've already said, many reasons why. Use a trust in your estate planning. It can be very, very helpful. There's sometimes it may not make sense to use that, but that's on the very low side, and you need a professional to give you that decision. Next thing is review and update your plans frequently. I try to meet with my clients every 3 to 5 years, because times change. There's also tax law changes, as we talked about in a previous episode. End of 2026, there's a lot of tax law changes that are going to go into effect if Congress doesn't act. And so that may affect your estate and what's going on there. So you need to update or at least review your documents. Make sure your assets are actually transferred to your trust. A lot of times people set up this great trust. They have all these ideas of what's going on, but then they're in probate court when the estate's in probate court when they pass away because they never transfer anything. They didn't move their bank account into the trust. They didn't redeed their house. They didn't move their business. All of those things have to be done. Otherwise, you just have really expensive paper. Next thing is to choose the right trustee. And unfortunately, that's usually not family. So you're going to pay a little bit for that service, but it's money well spent to make sure your plan is executed properly. If you're going to choose family, get 2 people on board. It's a little more administratively difficult, but that's on purpose. So that one person can't just take over, can't give everything away or give them to themselves or steal it or mismanage or whatever the case may be. So be very thoughtful. Make sure you know that individual and how they're going to act when that time comes. It's okay to be restrictive when you're doing your estate planning and your trust. Be creative. As you guys know, one of my big themes with my clients is plan as if you are still here. What are the things that are most important to you? Let's plan it that way. If you were still here dividing up this money, stringing it out, how would you do it? Okay, great. Then let's do it that way, not just give them a bunch of a chunk of money because you're gone. If that's not anything of how you would handle it when you were alive, why would that change when you pass away? It should honor what your wishes, your values, and your plan is. And so it's okay to be restrictive. It's okay because it's your assets. They're not entitled to anything. What you're giving them is a gift. And think about it that way. Last part I want to mention is it's okay to spend your money too. Like I said, it's your assets. Make sure you make that a priority. Spend it on things that you want. Give your money away now if that's important to you. Let your kids use it and see it and be able to thank you for it. Or take them on trips. Go do that stuff. No one is entitled to anything that you're going to leave to them. And so, they should be grateful for whatever they give, but don't let your kids dictate what you need to do while you're living. Okay. Take the time, take the money, take the vacation, have fun, get that new car, whatever it is, as long as it's not, going to bankrupt you or put you in a position where you're going to be financially unstable, go ahead and do it. The vast, vast majority of my clients have more than enough to live off of, and their kids are going to benefit from that. And they're living in poverty or trying to live paycheck to paycheck or social security to social security. And, that part hurts when they have the means to go get a new car and have some fun and spend time with family. So I encourage you to do that. And that's what I've got today. Hopefully that gives you some ideas of how to do your estate planning and the reasons why, so you can take action now. Make 2025 the year that you get your estate planning done, or whatever year you're listening to this. So that's it for now. We'll see you next time on the Trusted Podcast.
You've been listening in to the Trusted Podcast with your host, Blake Johnson. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, trustedepa.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others. Please subscribe to make sure you are notified each time a new episode is released each week.